Good morning, everybody. All right. Thank you all for joining us. I am trying to get my Zoom to show me the things it normally shows me so I can see when we're all in from the waiting room. And I think we are almost all here. So I'm going to go ahead and get us started with our Zoom housekeeping tips, like I always do. Happy to have you with us here today, and thank you for joining us. This is a reminder, like we give you all every week, that we are here to discuss general information, not to give legal advice. We did have several questions this week, like 4 or 5 questions, where folks sent in lots and lots of detail and really specific fact patterns that made it really clear that even if they didn't realize they were asking for legal advice, they were absolutely asking for legal advice. So we just will ask you to keep in mind for the questions that you send in via email, but also that you put in the chat, that we can't give legal advice here. We're just here to talk about general information and not legal advice. And by the same token, if somebody sends you one of our Q&A links and says, you know, you have to do this thing or you can't do that thing because of something that we said here, you can ignore them. And if you're in a position where you need legal advice, don't send the email to us, send the email to your association attorney so they can give you legal advice for your specific circumstances. And you'll see part of why I'm saying some of this as we go through the questions today, because one of the things that we do try to do is at least cover the topic generally if we can, even when the question submitted is too specific. So just do keep that in mind. And I just realized I went straight to that and I skipped over the Zoom housekeeping that I said I was going to start with. I think most of us are probably familiar enough with Zoom that we don't need this, but I will at least briefly remind everybody to please stay muted during the Zoom to reduce background noise. Your audio and video buttons are on your Zoom toolbar, wherever that is on your device. You can be on video or off video if you need privacy. We're fine with either. You are welcome to unmute yourself to ask a question verbally if you would like to do that during the Zoom, but otherwise, if you could please stay muted, that would be great. I did also pop a message into the chat telling people how they can submit questions in between our Q&A sessions. But if you want to submit a question today, you're also welcome to drop it into the chat. That's the best way to do that. So I think that might be our shortest announcement period in many months. And without further ado, Lisa, unless you think I'm missing anything, I'm going to jump to our questions.
Nope, no? Go for it.
Okay. All right. Our first question is this. Regarding resale certificate cost, is it $275 plus fees or $275 total, including all fees? And in parentheses, the person said fees usually from an outside vendor. So each of the statutes have a resale certificate fee section, and you can Google your statute, like if you're a Wakaiowa community, RCW 6490, and then resale certificate. Same thing if you're a Condo Act community, RCW 6434, and then resale certificate. And you can read the language. Both of them say, for the purposes of this chapter, a reasonable charge for the preparation of a resale certificate may not exceed $275. I think the statute is pretty unambiguous in saying that that charge may not exceed $275, period. The statutes don't care if you're the one to prepare the resale certificate or if a third-party vendor prepares the resale certificate. The statute also doesn't govern what the third-party vendor might charge, say, the management company or the association, if there's a contractual relationship there. Just like we often talk about, the management contract governs what your management company has the right to charge you for services, but that contract doesn't govern what you get to pass on to your owners. So what an association can charge a selling owner for a resale certificate is capped at $275, even if the association pays more for the resale certificate. And I don't think you can circumvent that statutory limitation by saying, well, the owner has to contract directly with that third-party vendor, and if they charge them more, like, oops, sorry, like, that's too bad. I think there's the potential for a statutory violation there on the part of the association if you're requiring them to go through a vendor that charges them more than the $275. I also think it's helpful or instructive to understand that there is currently a resale certificate bill being considered by the legislature that would do a couple of things. One is that it's trying to prevent or prohibit associations from requiring that an owner obtain a resale certificate from a third-party vendor. So all of the associations that I know that work directly with especially larger management companies typically go through like Condo Certs or HomeWise or some other third-party vendor for their resale certificates. And the way it typically works is that the seller has to establish contact with that third-party vendor, request the resale certificate, and it's provided directly to the owner by the third-party vendor. This statute or this bill, if it is passed by the legislature without being amended, would require that the association obtain the resale certificate from the vendor and then give it directly to the owner. Because the obligation in the statute to provide the resale certificate is an obligation of the association, not, some third party. So that's one part of what the bill seeks to do. The other thing that the bill seeks to do is to allow a rush fee of no more than $100 in certain circumstances, like if somebody requests a resale certificate in 3 days, the statute allows 10. You can pay extra to get it on a rush basis, but it caps that fee at $100. So what I think is this is really strong evidence that a rush fee is not currently provided for by the statutes, because if it was, they wouldn't be seeking to amend the statute to specifically provide for the rush fee. So the short answer is we think that the total cost to the selling owner at this moment in time, without the statute being modified by the current bill, is that the cost should be capped at $275, regardless of whether this third-party vendor is trying to charge more, regardless, even if there's a rush fee. So I would keep that in mind as you evaluate, for example, the fees of a third party that you're considering to use for resale certificates within your community. Lisa, did you have anything to add on that one?
Nope, not on that one.
Okay. All right, I'm going to jump to the next question because Lisa gets to answer a nice long one after this. The question is, what is the difference between RCW 6432-200 and RCW 6490-485? The short answer is that these are two sections from two different statutes about delinquencies and lien enforcement. So 6432-200 is part of the old act, but I think it's important to note that the new act provision or section on delinquencies and lien enforcement also applies to old act communities, and that's RCW 6434-364. And then the second statute the question submitter highlighted, which is 6490-485, that's the Wakaiowa provision on delinquencies and lien enforcement. So these are two different provisions that essentially do the same thing, but for different types of communities. Every community in Washington State, as we've talked about before, is governed by a different statute. If you're a condominium created before July 1st, 1990, you're governed by the old act. It's called the Horizontal Property Regimes Act, but that's a mouthful, so we call it the old act. If you're a condominium created July 1st, 1990 through June 30th, 2018, then you're governed by the new Condo Act. And if you're any kind of community in Washington created on or after July 1st, 2018, then you're governed by Wakaiowa. And which of the statutes governs your community depends on, are you structurally or legally, I should say, created as a condominium, and what year was your condominium recorded and created. There's also separately the HOA Act, which doesn't say a whole lot about delinquencies, and that's RCW 6438 is the chapter for the HOA Act. So until 2028, if you are an old act condo, 6432-200 and 6434-364 are your sections of your governing statutes that govern your ability to record liens, what has to happen when an account falls behind, associations' right to foreclose, right to seek appointment of a receiver, all of those kinds of things. If you are a community created on or after July 1 of 2018, then you look to the Wakaiowa section. And then in 2028, when Wakaiowa for All takes effect, all of this other stuff goes away, and the only thing left standing will be 6490 for all communities in Washington State, regardless of what common interest community type you are, or what your original governing statute was. Functionally, one of the differences that 485 has a whole lot more information, 6490 485 has a whole lot more information in it than 6432 200. But again, keep in mind that if you're an old act condo, you also need to look at 6434 364. One of the things that we'll talk about a little bit later in the Zoom today, if we get to it, is a question about the new delinquency notice requirements that took effect for all communities in Washington state on January 1st of 2026. You'll want to pay attention to that regardless of what your governing statute is. And if we don't get to it today and you're just really burning to know what it was we were going to say and what the new requirements are, if you look back, I don't know, maximum 3 months in our Q&As, you'll see that we've mentioned it a couple of dozen times and talked about it in pretty great detail, probably fairly shortly around July of last year, when all of the bills that were adopted by the legislature were signed by the governor, and when we knew, okay, now we know this is coming, you know, in January of 2026, we started talking about it back then so that everybody would be aware. I think that's all I've got for that one. Lisa, if you want to add anything, please feel free.
I think I would just say, if you're the member of a board or a manager and you have questions about these kinds of things, like what do we need to do if somebody's delinquent, then that's a question you should definitely direct to your association counsel if you're not sure what to do, and which part of this, which statute applied to you. Those questions would be perfect for that. Because it's a big question. What are the differences between those two statutes? Okay, next question. This is a 3-part question. I'm going to try and respond to each part separately so that we don't get them all muddled. Valerie, feel free to chime in if I miss something. So the first part of the question, these are all about secret ballots and balloting. The person that writes in asks that, or says that they're familiar with how California does their secret ballots, which is sort of a 3-envelope ballot system, where there's an inside envelope that has a secret ballot with no information on it. Then there's a return envelope outside of that has the signature line, so you know who it was that did the ballot. And then the big outside envelope is what was sent to the member. And so this person is asking would this kind of a system be legally permissible in Washington to comply with our secret balloting requirements and quorum requirements and everything else to do with voting? I'll start out by saying this is a pretty specific question, and I'm not sure I can answer it exactly as you want me to, but this is definitely not a requirement in the state of Washington. There's nothing in the statutes that says anything about a 3-envelope system or provides any specific detail except to say that if you are a Wakaiowa community, you are subject to the secret ballot requirements. And that is only for Wakaiowa communities until 2028. So I'll put that out there first, that if you're a 6432 community, 6438, 6434, this is not necessarily relevant for you unless your association has subsequently adopted Wakaiowa until before 2028. I think that this system could work if maybe you're an HOA and everybody has the same interest, same ownership interest, same voting power in your community. But if you're a condominium with different votes and different percentages for units and ownership interests, and the percentages vary, like most condominiums, I don't think this type of system would necessarily work. It might be, I think it just would make it more complicated, and you wouldn't be able to figure out what percentage was voted on each ballot, because you'd have to have identifying information. And I think then at that point, you'd not have a secret ballot. It might be reasonable to do that again if you have uniform voting power, but I think it may just be overcomplicating things. And it also assumes that you're voting by mail, which may or may not be the situation in your community. So I think you should you definitely talk to your association counsel if you have questions about how to conduct a secret ballot, and what requirements you need to perform. But again, this is a fairly limited number of communities at this point that are required to comply with this provision. So keep that in mind. And I think this is an overly complicated method for what we what needs to happen in Kiowa communities at this point. Did I miss anything, Valerie? That one got a little away from me. No? Okay.
Nope, I don't think so.
Okay. Second part of this question is when nominations are taken from the floor at a meeting, and if a member has already submitted a ballot and then wants to rescind their vote in favor of a newly nominated candidate, is the member legally permitted to replace or revise their ballot after it has been submitted? And I think the answer to this question is it depends. It depends on when the revocation is made and what type, what are we talking about here? If we're talking about a secret ballot, that may be a complicated issue, but an owner, a person usually has a right to revoke a ballot before an action has been, before a vote has been completely counted and completed. So you can revise your vote if the vote has not occurred, has not been counted. You've notified the association that that is your intent to change your vote, and the results have not yet been tallied or announced to the community. I don't know if you are having, votes or nominations from the floor, why there would have been a prior ballot sent in or ballot sent out to owners. So that may be a different question, but wanted to also mention that Kiowa has just been amended to require that when you're sending a ballot out, you have a blank space for write-in candidates, so you don't have this issue. So if you do get a different nomination or a new person comes to light after the person is, after the ballots have been sent out to owners, there's a space for them to be able to write in that candidate. But the short answer to your question is yes, you can revoke your vote as long as the voting has not been tallied and published to members. Anything you want to add to that one, Valerie?
No, there's a follow-up question in the chat though,
Yeah.
and it says, if this physical ballots are now required to be mailed or sent out, how can the vote remain secret if the management company would receive it via mail? And I think the short answer to that question is it's not possible for ballots to remain secret from everyone. Otherwise, they could never be tallied, right? Somebody is going to know who voted which way. And you have to be able to identify who voted certain ballots, especially in a condominium community with variable percentage allocations, because votes are weighted differently. What a secret ballot means is they are not subject to disclosure to other owners, for example. And so as long as your community, if you're talking about a Kiowa community that is subject to the secret ballot statute, our best advice would be go through the statute and then work with the association attorney to come up with a voting method and a tallying method that respects the confidentiality requirements of the statute, but that allows you to effectively tally the votes in the community, because somebody's got to count the votes. They're not going to be secret from everybody. They just are not subject to disclosure to other people. When somebody asks, like, I want to see copies of all the ballots for who voted which way on this issue, which, if it's an issue that's covered by the secret ballot statute, you have an obligation as an association not to disclose who voted which way. So then you have to decide, do we provide the ballots but redact the voter information from it? Do we just provide a tally showing, how, like, what the total votes were? So paper ballots are still required in many situations, and they don't violate the secret ballot statute. So sorry, Lisa, to jump in on that one,
No.
but go ahead and keep going with this topic.
Please do. The final part of this three-part question was actually about virtual meetings, so a slightly different take on it. If an association conducts a meeting virtually, how can owners submit their votes in compliance with the secret ballot requirements when there's no physical ballot to complete? And again, the statute does not tell us how to have a secret vote or use secret ballots, but you probably would have the voting done by mail or electronically, which would be separate from the meeting itself. So you may be having a meeting, but the votes would have already been submitted either by an electronic method, one of those companies that handles voting. You've probably seen a lot of ads for those or are familiar with those, or the ballots would have been sent out prior to the meeting and collected. And then whoever the person is that is reviewing the ballots and tallying them up for review would be doing that separately. You'd want to make sure you had a very fair process for how to nominate and how the balloting worked outside of that meeting. But the meeting itself, you would not, obviously, there's no way to raise a hand and have that be a secret ballot. So it would have to have been done prior to the meeting. And then the meeting itself would be for publishing basically those results to the community. Um, I don't know if I have anything to add to that one, Valerie, anything you can think of?
Yeah, I mean, there's another follow-up question in the chat. Do the results need to be published, and do we
Oh.
get to know how many votes each candidate got? I think there isn't a requirement for the association to publish the specific results, meaning the percentages or whatever, but there, of course, the association has to, like if it's a board election, the association has to announce who won that election so that you know who your incoming board is. Um, Owners do also have the right to request the opportunity to review association records, including those records related to voting. But in this scenario, like I mentioned before, because that type of vote is protected in a Wakaiowa community by the secret balloting procedures, you would not have the right to see who voted which way, but you might then be able to request to see, like, show me the spreadsheet where you tallied the total percentages for, who got what percentage of the vote.
And this may be one of the situations where you have someone that everyone agrees is impartial who's doing the counting so that owners aren't suspicious. I think you have some situations where folks get a little bit concerned that there was some rigging. I can't imagine why there would be, but just to, on the up and up, have an impartial person as the person who's
Yep.
doing the counting.
So we've had situations where our clients have paid for one of our attorneys to attend a meeting to tally the votes.
Mhm.
We've also had situations where people are like, the attorney's a liar. We don't trust anybody to count these votes except for me. So that's a tough situation because, maybe in that situation you hire like a parliamentarian or someone like an outside consultant that has no connection to anybody within the community. So they can be a party that has the most perceived lack of bias. Couple other follow-up chats or questions in the chat on this. Could the homeowners chat their vote to just the manager? I think that is acceptable as long as that is a method that the board has approved and it maintains the secrecy of the ballots with respect to those subjects that are covered by the secret balloting statute.
Mhm.
Separately, there's another question in the chat that says, does quorum have to be met at an annual meeting in order for the ballots or election to be valid? And the answer to that question is yes. You cannot do association business at an annual meeting where no quorum has been met. So then what you have to do is take a step back and look at what methods of voting might be allowed in your community, even if you can't make quorum at the annual meeting. So for example, could you conduct the vote by mail and collect a combination of absentee ballots and proxies that would be sufficient to allow you to make quorum, not at that meeting, but via the vote by mail process, so that you could actually conduct a valid election? Did you have anything else you wanted to add before we keep moving, Lisa?
Nope, I'll just go. I think it's me, the next one too. So I'll just go on to the next question, which is not about voting. This question is, if there is a legal search warrant for a unit within a condominium building, is the association obligated to provide access through the security gates and doors to the police executing the search? I will step back and say that this is a pretty specific question. If you have actual questions about this type of thing, talk to your association counsel, because I think, you're going to want, there may be some nuance to your question. But generally speaking, if the person executing the search warrant has a valid judicial search warrant, not necessarily an administrative search warrant, but a judicial search warrant signed by a judge, that is for a specific unit in your condominium building, I think it is reasonable to allow that person access to the common areas of that condominium complex or building. I think the liability is probably fairly low if you are responding to a valid judicial warrant and allowing someone into the building. I think that the question of allowing them access to the unit is a different question. And if the warrant itself was very specific and said, and the unit or something, or ordered the person to allow access to the unit, that might be something you could look into. But generally speaking, I think it's, if if the access question is just to the condominium complex or grounds or building, I think that is probably a relatively low risk if you've got a valid search warrant. Most governing documents aren't going to say whether law enforcement, has a right or an easement right or anything like that. So I don't think you're going to find the answer there. But I think, you're going to have to look and see what the warrant says, and determine whether or not it makes sense to, what kind of a warrant it is and whether or not it makes sense to allow access to the building itself. We had some conversations about other types of action and entry into units prior to this, but I think the question was about the building and not the unit, and I think the answer is it's probably a relatively reasonable response to allow access to the building, not the unit. Anything you want to add to that, Valerie?
Yeah, I think one thing that we didn't cover when we were chatting about this in our prep meeting is a lot of folks don't know the difference between a judicial warrant and an
Yeah.
administrative warrant. And so I'm going to let this be my plug that I give periodically for establishing a relationship with an association attorney if you don't already have one. This is exactly the kind of scenario where having a relationship in place would mean that you can call my office and say, there's a police officer here or some type of law enforcement officer here. They have a piece of paper that they say is a warrant and I have to let them into the building. What should I do? And then I or Ken or Lisa or whoever is the attorney that's best able to assist can get on the phone. You can send us a copy of the warrant so we know what we're looking at. And then we can give you specific advice for whether you should allow them entry under the circumstances. So if you don't have a relationship with an association attorney, establish one now so that you're not scrambling and just guessing whether you should let somebody in the door when something like this happens. I will also offer that, the elephant in the room that I'm sure a lot of folks might be thinking about is federal law enforcement activity recently by like ICE and DHS. And we heard a lot about this at the National Law Seminar. I know that this has been a thing in some communities in Washington, but it seems like it's a lot more common in other parts of the country right now. And we've got folks that are talking about things like having a policy, like an actual written policy for how to respond when law enforcement comes knocking at your door in your community. We had folks that were talking about insurance related implications, liability for the association if they improperly allow access. What happens if they are allowed in and they damage someone's home? So you want to be really careful. And I think the sort of the biggest takeaway that I would say is a layperson without legal training, without the ability to discern between different types of documents, shouldn't be forced to make a decision about something like this on the spot without somebody with a little bit more training and experience to help them through that decision. But the flip side of that is I'll repeat something that was said multiple times at the National Law Seminar, which is we don't ever want people to put themselves physically in harm's way. So if you ever feel like saying no is putting yourself at risk, keep yourself safe, keep your staff safe, keep your management folks safe. So your safety is the number one priority in these moments. The other thing that I think is worth mentioning is, well, dang it, now I just lost my train of thought. There was something else that came up at the National Law Seminar that I thought was really helpful with all of this. If I think of it, I'll come back to it later. I don't want to hold us up here so we can keep moving through the topics. If anybody has follow-up questions, you're welcome to put those into the chat. Next question. There seems to be a 3-year statute of limitations on back debt, but a 6-year life on liens on condos. Is this a contradiction? And it's so funny because we did all the prep for this question, and now just reading it out loud again, I sort of crystallized sort of a flaw in the assumption behind the question. So the 3-year statute of limitations on collecting unpaid assessments is for old and new act condos. The 6-year statute of limitations is for HOA Act communities and Wakaiowa communities. There is no scenario in which a condominium has a 3-year statute of limitations, but a 6-year lien. That doesn't exist. So in a condo association that is governed by the old act or the new act, you have 3 years to collect unpaid assessments. And if you take no action during that 3-year period of time, then some part of the debt gets to be older than 3 years, everything that's older than 3 years becomes uncollectible legally, whether you have a lien recorded or not. Recording a lien does not extend the statute of limitations. It doesn't stop the statute of limitations. The only thing that stops the statute of limitations from making debt that's older than 3 years uncollectible is filing a lawsuit. So the other thing that I want to say is a comment that Ken made when we were chatting beforehand. And it's usually the drum that I beat. So I chuckled that it was him saying it. But don't ever let your debt get this old. Don't ever let your debt get so old that you start to worry about the statute of limitations. We're not talking about right now, because this question is related to condos, we're not talking about HOAs with low annual dues where you're sort of caught between that catch-22 of the statute of limitations on one hand, but the threshold balance due for a foreclosure lawsuit on the other hand. But also keep in mind there are other types of lawsuits that can help you collect unpaid assessments. So if you're a older new act condo, 3-year statute of limitations, HOA Act or Wakaiowa community, 6-year statute of limitations. But in either case, you should never wait long enough to take action for this to become an issue. And do keep in mind that one of the things that will be interesting to watch in 2028, when Wakaiowa for All becomes applicable to everybody, is that we will now have a whole bunch of communities that have a statute that says the statute of limitations is 6 years, but a declaration that says the statute of limitations is 3 years. And it's an open question whether courts will decide that the statute overrides the governing documents, or that the governing documents, which are a contract between the parties and which are more favorable to the owners in that scenario, control in that situation. And so I would rather not have to argue that issue in court for my clients. And the way that we avoid that is, number one, don't let the debts get that old. And number two, look at whether amending your governing documents makes sense for your community in advance of or in preparation for that 2028 Wakaiowa for All date. Am I missing anything on that one, Lisa?
No, well, just being the drum. Don't let your debt get old, please.
Yeah.
Okay, next question. If the board elects not to add commentary from owners into their board meeting minutes during the homeowners forum or from the homeowners forum, but an owner objects to having their concerns, quote unquote, hidden, how should this be handled? And just to kind of step back a little bit, we've had a lot of conversations about this requirement now that board meetings are open and that there is an opportunity for comment by homeowners, and that's what this person's referring to as a homeowners forum. I will say that there is nothing in any of the statutes or anywhere that I can find that requires that the minutes of your board meeting include commentary of the owners. The statute just says the owners have a right to, or the board needs to provide an opportunity for the owners to have a period of comment. I do think, however, that there's no harm in mentioning in your minutes that that there was a comment period and that the following topics were raised, or something like that. That can potentially help you in the future in determining what you want to talk about at board meetings. It can direct board business to know what the owners are feeling, what they're talking about, and you'll have some record of what happened to that meeting. If someone says later, "Oh, we never talked about this kind of landscaping," and someone says, "Oh, well, it was in the homeowners forum," and you see it's mentioned there in the minutes. If the board is holding firm and doesn't want to include that stuff in the minutes, I mean, you can say, look, it's not in the statute. Robert's rules doesn't require it, or et cetera, et cetera. I think you have ground to stand on not to include it, but I think there's no reason not to include that information in there. You could make something, as I said, very generic, just general topics that were covered in the forum. You could say, so-and-so asked about landscaping and leave it at that, or so-and-so from this lot want to know about safety, whatever the issue is, and then just kind of leave it at that in sort of the open topic section of your minutes. And you could ask, you could agree if this owner is particular that you submit their statement into the record. As, I as the board member motion to submit John Smith's commentary on landscaping into the minute, into the record, and put that in the minutes. Something like that could be done. I think the short answer is there's no requirement to do it, but there's no harm in doing it. And in fact, it probably is useful for your community to have an actual record of what was going on then. So when you look back on the minutes in 2 years and you wonder, has this always been an issue in our community? And you have a record of it in your minutes, that's a very effective tool for homeowners and board members to know kind of get the pulse of what's going on in their community. Anything you want to add to that, Valerie?
Yeah, as you were talking, I was just thinking that for every owner that would demand that their comments be included in the minutes, there's also probably owners out there that don't want their name in the minutes
Right.
or their comments in the minutes. So one way that you could include some of the commentary without calling out specific owners is you could just say, like in the agenda, we started with the owner forum, and then you could have a bullet point list of the topics that were raised. You could say, 6 owners commented. The topics included, landscaping, the proposed amendment to the declaration, and the 2026 budget. No board response or whatever the thing is, because
No
do
action
keep in
taken. Yeah.
mind that owners commenting during the owner forum part of the board meeting should be just that, an opportunity for the owners to address the board. It's not a time for the board to argue with the owners. It's not necessarily even a time for the board to answer owner questions. Although if something is really simple and low risk, I think that's fine. It's really an opportunity for the owners to comment, and that's it. And you take those comments into consideration if they pertain to votes that you are taking later in the meeting, right? And that could be something where you decide to document in the minutes, the board, in the minutes, sorry, the board voted on whatever issue, the board considered the report from the accountant and the comments from owners at the forum, and then somebody made this motion, seconded, here's how the vote went, and this is the action that the association took. And also, one of the other things I'll comment about is something we've talked about before, which is the minutes are not intended to be a transcript. They shouldn't be 27 pages long. They should be 1 or 2 pages, maybe 3 at the most if there's a lot of detail or it was a long meeting or it's a large community, 4 pages maybe. But it should really be a high-level summary of what happened at the meeting and specifically the actions taken by the board. Nothing else needs to be included in there. And I think that including that very brief summary at the beginning of the topics covered at the owner forum without naming names would be a good way to balance people who want you to include the information with other people who probably would be like, don't put my name in the minute. So, just anticipating that kind of objection from people. All right, next question. I can't remember. Are you doing this one or am I?
I think it's you.
Okay, I'll do it. If the governing document amendment voting was sent out in the last quarter of 2025 and owners can submit ballots until the beginning of January, does the continued voting fall under the new secret ballot law, or can owners host a membership meeting to collect additional votes? So if you are a Wakaiowa community, the secret ballot rules went into effect in July of 2025 anyways. So the entirety of this vote would be protected by the secret balloting rules. And whatever method of voting you are allowing, you just have to maintain the confidentiality of those ballots to be compliant with the statute. You can do that with paper ballots and you can do that with a membership meeting. If you are not a Wakaiowa community, you are not subject to the secret balloting requirements of the statute. And so they would be totally irrelevant to you. So I think that answers the question. So if you are a Wakaiowa community, the secret ballot statute applies to you, and it applied to you last year too, because that one took effect in July of 2025 for Wakaiowa communities. And so you need to comply with the statute for the entirety of your voting process, including the part that started in 2025. If you're not a Wakaiowa community, then you're not subject to that statute, and this whole thing is irrelevant to you. Lisa, did you have anything you wanted to add to that?
Nope. I'll just go on to the next one. The next question, I would like to know if it is okay for an HOA to hire an owner and pay them to do maintenance for the association. could this be considered a conflict of interest? I'll start out by saying I know we've had a number of conversations over the past almost 6 years, just sounds wild to say, about this. And I think our general recommendation is don't hire an owner as an employee of the association. If you do want to ask an owner or have an owner do work for the association, they should do it as an independent contractor and get a 1099 form instead of being an actual employee of the association. All of you board members are voluntary. You are not and should not be charged with trying to figure out whether and what L&I reporting needs to happen, taxes, et cetera, et cetera, et cetera. I think that it makes far more sense if this is something that the board decides to do, that this person be employed or not be employed as an employee, but rather hired as an independent contractor. I don't think, back to your question of, is this a conflict of interest? I don't know that it necessarily rises to a conflict of interest, but I think that any decisions like this need to be made, like all decisions, out in the open. If you're considering using the services of an owner and you need to review, the costs and all the work and all that stuff, just like you would with anyone else. But the complicating factor is, of course, that they are an owner there, and you just want to make sure that you're not, or that, sorry, that they are a person, that you don't want to make sure they're not employed by your association. But keep in mind that there are lots of other requirements that come with hiring folks, taxes, and things like that, the L&I, all that stuff I mentioned before. Also want to mention that be really careful about using compensation, things like assessment or dues as compensation. I've seen some things written where an owner does some kind of work for the association and they say, well, we're going to waive their monthly assessments in exchange for this. I think I'd be really careful about doing that. Again, just make sure everything's out in the open, that this person is not an employee of the association. And I think you're probably okay in most cases, but definitely talk to your association counsel about this kind of thing if you have specific questions about it. Anything to add, Valerie?
Yeah, I think I would like to just say a little more bluntly that waiving the dues is
Yeah.
compensation. So you can't
Yes.
do that to avoid IRS reporting requirements. And the other thing that I would say, just as a practical matter, is you want to make sure that the owner is qualified to do the work that you're hiring them to do, right? Don't just hire them because they're cheap and they live in the community and I don't know, they're retired and they're looking for things to keep them busy. That might be it might be very reasonable to do it if the person is a retired, I don't know, like contractor and the work is like maintenance work around the community. But make sure that they are qualified to do whatever work it is that they are being hired to do. Also, when you hire contractors, vendors, you should make sure that they have things like insurance and that they're licensed to do whatever type of work it is that they're doing. And just because you're hiring an owner does not mean that you shouldn't still do your due diligence in regards to those things. All right, our next question is also regarding minutes. Should reports from board members and committees be written and attached to the minutes? Our minutes read like an agenda and as a legal document are basically useless. Should draft minutes be sent to owners before the next meeting when they are approved, especially annual meeting minutes? The owners are not receiving minutes until almost 2 months after the meeting was held. So I'm gonna say two things. First of all, your minutes are not a legal document. They're an association record, but they're not a legal document. And the only thing that the statute requires that the minutes reflect is, and I'm going to read right from the statute here, just like Lisa did earlier, the decision on each matter voted upon at a board meeting or unit owner meeting must be recorded in the minutes. That's it. The minutes do not require inclusion of paragraphs of information and reports and whatever else. If the vote on a particular matter relied on a report, it might be reasonable to attach the report to the minutes, but that is not required. And it might depend on what we're talking about. But also, reports and information, reports that the board relies on in making its decisions do have to be made available to the owners who request it. So it does not have to be included in the minutes, right? Because let's say you're making a decision on a big a big project within your community, some big like construction related contract within your community. The volumes of information that the board might rely on could include multiple bids from 3 or 5 different contractors. It could include a scope of work. It could include your engineer's report. It could include recommendations from your attorney for the contract and what type of AIA contract should be used in that scenario. And all of a sudden, you're looking at a set of board meeting minutes that are this thick. That's not practical, and it certainly isn't required by law. However, the statute does require that information or documents that are relied upon, and I'm going to actually just read from the statute. And then this is from RCW 6490-445, subsection 2G. If any materials are distributed to the board before the meeting, the board must make copies of those materials reasonably available to the unit owners, except that the board need not make available copies of unapproved minutes or materials that are to be considered in executive session. So I think you have to make available to the owners the board packet. I do also think you have to redact anything that is prohibited to be disclosed. So anything that's attorney-client privileged, and anything that where there's a justification for withholding the information from public disclosure. So like if you're in the middle of a competitive bidding process and it's the kind of subject that would otherwise be appropriate for executive session, you're not including that in the packet of information you're making available to your ownership, even if it is information that the board relied upon in making its decisions. The part that I just read to you also speaks to your question about whether draft minutes have to be provided to your ownership. The statute specifically provides that they do not. I will offer the one exception is that the HOA Act does require that meeting minutes from your association meeting must be made available to the owners within 60 days or after, must be available by 60 days after the meeting. And what this means is if we're talking about your annual HOA meeting, that you are going to have a draft set of minutes that the board might approve the draft internally, right? And that draft set of minutes has to be made available to your owners within the community long before it gets approved at the next association meeting a year following the last one. And you should just make sure that those minutes are clearly marked as a draft because they're not the approved official minutes of what occurred at that meeting until they are approved at the next meeting of that type. Hopefully that makes sense and isn't too convoluted. So if you are in an HOA and you're not under Wakaiowa, the rules are different. The Condo Act is silent on a lot of these questions. Minutes of board meetings do not have to be provided to the ownership in draft form. Although if an owner submits a request for that and you clearly mark it as a draft, then that's fine. I don't have an objection to that. It does not become an official record of what happened at the meeting until it's approved at the next meeting. And if the owners really care about what's happening at the meetings, they can go to the meetings. And I promise I don't mean that in a snarky way. The meetings are now all by law open to the ownership. And a lot of communities are holding these meetings via Zoom. Most of the time they're being held in the evening, which means for a lot of us, not everybody, I recognize some of us work non-traditional hours, but for a lot of us, the ability to attend those meetings is easier than it's ever been before. So I think that's where I'll leave my commentary on that question. But if you have anything to add, Lisa, please do.
I would just say, I mean, the comment, the question about not receiving minutes for more than 60 days or something like that. I mean, it also just depends, board meeting minutes are approved, as Valerie said, the next meeting. If you're meeting quarterly or you're meeting less than 1 month, or the board just hasn't gotten around to approving those minutes or publishing them to you, I don't think 60 days is that unreasonable, honestly. That's probably the natural cycle of a board meeting. Approved minute is about that because of monthly meetings. But again, as Valerie said, if you really want to see them, number one, go to the meeting, or number two, you could probably ask for a draft copy, and the board should be willing to make that available to you, again, as long as it's marked as draft. Let's see. Next question. If you rent out your property on the open market, do you relinquish your rights or those of a relative to use the property amenities when you are not a resident? When an owner rents their property In other words, are they still entitled to use the amenities of that property? I'm assuming in a condominium situation. For instance, things like bike storage, kayak storage, beach, pool area, etc. Um, I think this is a pretty specific question, but I think, number one, look to your governing documents. It's possible that you may have specific things laid out as far as your amenities go, and that you might have an answer to your question right there. So first thing I would say is take a peek there. But generally speaking, if an owner or somebody rents out their unit, they transfer the rights that come with that unit to the person that is occupying or renting out the unit. So using that argument, those amenities would then, the right to use those amenities would be transferred to the occupant slash tenant of the unit. Um, so I think that is the basic answer to your question. If I own a condo and it has a pool, but I rent it out to Valerie and Valerie lives there, Valerie gets to use the pool. I don't get to use the pool. The caveat to that question is Valerie invites me as her guest to come use the pool. Then yes, I could use the amenity as a guest of the tenant. But I think generally speaking, the rights of to use those amenities would transfer with the tenancy of the unit. There are lots of questions about who's a tenant and what's a tenant, and is my sister who uses the apartment a tenant. That's probably a more complicated question than needs to be answered here. And if you have really specific questions about that, talk to your association counsel. But generally speaking, if you're having a problem with owners using those amenities, that may be the answer to your question, is that the person who has the right to occupy the unit has the right to use those amenities. Anything you want to add, Valerie?
I just want to emphasize that this is very document specific and fact specific. And so if you are hearing what we're saying here and thinking, oh, great, I can go back, and I don't even know who submitted this question, but oh, great, I can go back and tell everybody in our community that the owners are not allowed to use the pool if they are renting their unit. Slow your roll there, Turbo. Make sure you check with your association attorney before you take any action based on the information that we're sharing here, because it isn't legal advice. And I know that we say that a lot, but it's because we have learned that we need to say it a lot. Let's just put it that way.
And also think of optics. That's also the other thing. Is do you want to be the person saying, get out of the pool?
Right. And the flip side of that, I can totally understand in a community of 100 units, if 50 of them are rented, and for all 50 of those, both the tenants and the owners are parking in the community, using the pool, and availing themselves of the amenities, that's a lot of crowding. It's a lot of wear and tear on the common elements. So I can understand this being a valid concern for a board of directors. I just don't want you to make any decisions based on what we're saying about it here. All right, next question. Can you please recap the duty of care that a board of directors is required to exercise? If a board makes a bad decision, how do courts and insurers distinguish good faith decision making from negligent inaction or failure to meet the duty of care? And I want to start this by saying this was the most general way that we could rephrase what was a multi-part, very specific question that was submitted by the person who was interested in this topic. The question as it was submitted was way too specific, and it also felt to me like it was angling for a certain answer. And so we can't answer questions like that. We're not going to do that in this forum. But I did feel like it was reasonable to recap the duty of care that we see for our communities in Washington State, because I think that's always a helpful reminder. So I'm going to start with the duty of care from Wakaiowa, and it says the board member's standard of care in the performance of their duties, officers and board members are required to exercise the degree of care and loyalty to the association required under RCW 2406153. And that statute says that a director shall discharge their duties, A, in good faith, B, with the care an ordinarily prudent person in a like position would exercise under similar circumstances, and C, in a manner the director or officer reasonably believes to be in the best interest of the association, the corporation. So the reason I start there is because that's actually the language that we put into our restated bylaws when we're drafting them for our clients. And in a couple of years, of course, Wakaiowa will be the only statute standing. And so this will be the duty of care that's applicable to all communities in Washington State. I think it's reasonable to note, though, that the duty of care under the Condominium Act is different, and it's just that board members have to exercise ordinary and reasonable care. And I would also like to point out the case Riss v. Angel, which we've talked about in this Zoom Q&A many times before. Under that case, the courts interpreted the duty of care for community associations to require that board members make reasonable inquiries and rely on objective information in making their decisions. I also think it's worth remembering that courts look at the totality of the circumstances to determine whether a board has acted in good faith, which is always an issue of fact, and the intent of the acting party is important. And a bad decision, when you're looking at it after the fact, does not always mean that a board acted in bad faith or failed to meet its duty of care. So I think reasonable minds can disagree about what that duty of care looks like in practice, but that gives you some broad strokes about what the duty of care is in Washington State. And Lisa, did you think there was anything for us to add on that one?
No.
Okay. So we have some questions in the chat. I think we have time to maybe try to get to one or two of them. One is, here's a question from a board member. While video and audio recording board meetings is overall not recommended, would recording the meeting with a data retention policy of 30 days suffice? The board believes that telling others the meeting being recorded keeps people from acting wild. Okay, that's interesting. Well, here's the thing. There's no rule that prohibits you from recording board meetings. The issue is that when you're recording them and retaining them as an association record, then they are subject to all of the normal disclosure requirements that association records are subject to. And on top of that, the recording of the board meeting is not the record, the official record of what happened at that board meeting. The minutes are the official record of what happened at that meeting. We have a lot of clients where the board will record the meeting for the purpose of the secretary being able to use it to go back to refer to what all happened, who made the motion, what the vote was on a certain issue as the secretary is drafting the minutes. And then the recording is destroyed when the minutes are approved. I don't think there's anything wrong with that. I don't know if I believe that being told the meeting is recorded keeps people from acting wild. I also think that if you have a problem with owners acting wild, then your meeting chair needs to take a stronger role in how they conduct the meeting, because there are statutory provisions that allow you to eject people from board meetings if they don't behave after they've been warned. And so especially if you're having your meeting on Zoom, for example, you can tell people, if you don't stop talking, the owner forum is over. If you don't stop talking during the board meeting, we are going to mute you. You can mute that person. And if they keep unmuting themselves, then you can just remove them from the meeting and not allow them to come back in. And you can do the same thing in person, although I do realize that's a little bit more complicated. So I think recording the minutes is less likely to require owners to behave or motivate them to behave than a strong meeting chair is to do so. I don't know if you have anything you want to add to that one, Lisa.
I was just going to say, the nice thing about video meetings is you can mute and exclude folks if they are not cooperating also. Yeah. So, yeah. But I don't have a problem with if there's a limit on the amount of time someone's going to keep a recording. I think that is probably okay.
Okay. We have, I think, one other one that we can get to from the chat, and it is this one. Can a board properly notice a meeting that begins with executive session and opens to homeowners later, or does this conflict with open meeting or homeowner forum requirements? I think you saw the writing on the wall in the way that you drafted your question. The statute specifically says this: at each board meeting, the board must provide a reasonable opportunity for unit owners to comment regarding matters affecting the community and the association. The board must provide at least 15 minutes at the beginning of each meeting for unit owners to comment about agenda items before the board votes. The board may place reasonable time restrictions of not less than 90 seconds per unit owner, except for that the time per unit may be reduced and allocated equally if more than 10 owners wish to comment. I think it is very, very clear and unambiguous in the statute that the owner comment period must be the first 15 minutes of your board meeting. And here's the rationale behind it. What's the point of an owner comment period after the votes are already done? And so clear statutory language. The basis for it is also pretty clear and easy to understand. I don't think you can start with an immediate executive session. I think you have to start with the owner comment forum.
Yeah, you could quickly do executive session after the owner forum if you
Mhm.
wanted to, and then have the on the record votes. That's possible.
Agreed. Agreed.
I think we're out of time.
Yeah, we are out of time. That takes us right up to 11 o'clock. Thank you for joining us today, and we'll see you guys back here next week. Bye,
Bye,
everybody.
everyone.